I work at Boundaries and Roper, a firm out of Milwaukee. We have about 200 attorneys around the state. I work out of the Appleton and Oshkosh offices from the Valley. I've been working with Tammy and Bev on HR issues for 6 months or so. We got a handbook update, and now it's kind of just general outside counsel comes up. Asked me to come talk about harassment and appropriate workplace conduct, a very appropriate and timely seminar. I've been doing a lot of these with employers in the last year, 2 years. And what's interesting is that it is an issue that's become put on everyone's radar due to the news reporting and media attention, but the change isn't associated with any change in the law. The legal definition for harassment is all the same. The hearing process, we'll talk about that briefly. But the law is the same. The public attention and awareness is changing, and that kind of changes how employers respond. I think you have to be cognizant of both components. What are your legal obligations and what triggers your legal liability? But now there's a separate component of analysis that you have to do is, okay, this is outside the statute of limitations, or this doesn't rise to the level of sexual harassment, so we're not worried about it in a legal sense, but we have employees out there who are unhappy with us, or who could say something on Facebook or take it to the news media who are anxious to report stories like this, or at least listen, and now you're kind of litigating in the court of public opinion. And what does that look like, and how do you have to monitor and get ahead of that? The ultimate goal of all of this is not avoid legal liability, but create an atmosphere where people feel comfortable coming to work, and if they have an issue, they feel comfortable reporting that problem, and then they feel comfortable and confident that the employer is going to respond promptly and appropriately. So you heard me talk about kind of the distinction between what is recommended and what is legally required. Again, that legal standard is one thing, but we're going to be striving, and we encourage employers to strive for a higher standard that kind of addresses issues long before they rise to that legal definition of harassment. So what do these claims look like? What does litigation in this area look like? There's a state and federal component. Complaints can be filed with either agency at the federal level. It's the Equal Employment Opportunity Commission at the state level. It's the Equal Rights Division of the Department of Workforce Development. At the federal level is pretty standard, straightforward civil litigation. You file a complaint, the EEOC looks at it. Unless you're a Walmart or a large employer with systemic discrimination or harassment, they're not having their in-house attorneys. The federal attorneys aren't prosecuting those cases 9 times out of 10, 99 times out of 100. The employee is getting a right to sue letter. They can go into federal court, and there's some damages that are available at the federal level but not the state level that are beyond the scope of this presentation that would encourage people to go the federal route. But again, 9 times out of 10, we're talking about the state level. At the Department of Workforce Development, all complaints are automatically investigated by a state investigator for what's called probable cause, meaning reason to believe that this has happened as alleged. There's a probable cause investigation. If they find probable cause, the case is go through a merits hearing. If they don't, there's an appeal process. But what I do with employers and how I get involved is drafting the initial position statement. When the employee files a complaint, the ERD sends a letter to the employer that said this is the allegation. What are all your facts and evidence in response to this allegation? That's why this seminar is very important, because I need, as the employer's representative, I need documentation, I need history, I need witness statements, I need knowledge of the circumstances from the people who have dealt with the employee on a day-to-day basis, and then the supervisors and the managers who have heard complaints, addressed complaints, and responded appropriately. If we're not, as an organization, getting complaints to the supervisors or to Tammy and Bev, getting them to the right people so they can be dealt with appropriately, that creates liability. If you're working with a coworker and you don't have a supervisory relationship, but you hear something or you see something that's inappropriate, and you haven't reported it, that can create liability. The important thresholds in any harassment case when you're dealing with coworker and coworker harassment is 1, employer knowledge, and 2, employer response. So in order for the employee to be successful, they have to establish those 2 elements, knowledge and inadequate response. The knowledge piece, again, that's where what you see on a day-to-day basis and the supervisors and the managers, what you're hearing on a day-to-day basis, that's imparting knowledge to the employer. And that's why it's important when you have that knowledge that you don't sit with it, that you report it to the appropriate person, so it's handled accordingly. And it might be nothing, but you shouldn't be the one to make the decision whether or not it's nothing. Make sure that it goes to the appropriate person. And then the other piece is appropriate response. And that's not really a decision that any of you make, it's very case specific, but the liability is triggered if the report is made, investigated, substantiated, and then the appropriate response isn't made. If the person wasn't separated, or if the person if the situation wasn't handled correctly, the employee still felt like they were being subjected to a hostile work environment, again, that triggers liability. A subtle twist in the law when you're dealing with supervisor to subordinate discrimination. There's no knowledge requirement, there's no right to, the employer's right to kind of remediate or address the issue is lost when you have a supervisor harassing a subordinate. The law says you're prima facie liable, on its face, you're liable when you have your supervisors harassing your subordinates. The idea being, when we have two coworkers, we're going to give the employer an opportunity to hear about it and fix the issue before we hold them responsible. But when someone who's in your supervisory position is doing the harassing, you've lost that right, because the knowledge is already imparted to you. It's your supervisor who's harassing. And then, again, that additional step is lost. So supervisor harassment is even a more serious offense and creates even more direct liability for the employer. So supervisors in here, don't do it, but more seriously and appropriately, if you're seeing something inappropriate by a supervisor, either you're at the supervisory level or you're an employee, it's important to report that as well. Again, the thing that I will repeat throughout the presentation is when you observe something that's inappropriate, make sure that it's reported to the right person. Finally, before I get into some more of my PowerPoint, this is an informal presentation. If you have any questions at all throughout any of this, please feel free to interrupt me and ask those at any time. So like I said, the harassment issue is, the harassment topic is very much in the public eye through the news media and through reports and the way that other employees are being dealt with, and they're outside of the legal realm. It's in the public eye, again, in the court of public opinion, but none of this, very little of this is being litigated. You look at the Cosby case, I think there was only one accuser who was within the statute of limitations. You look at the Harvey Weinstein case, whether or not it rises to a criminal standard is one thing, but most of the civil cases are outside the statute of limitations. Everything with Brett Kavanaugh is outside the statute of limitations for civil liability. So under the Wisconsin equal rights law, there's a 300-day statute of limitations. So if you're getting complaints outside that 300 days, you can think, well, the legal liability isn't there, but how should this be handled? How should this be dealt with appropriately? And even without the legal pressure. And again, the encouragement, the recommendation is to employers is to hold themselves above the legal standard. If they have a complaint that's outside that 300-day statute of limitations, maybe there is a legal obligation or potential legal liability, but of course the recommendation is still to investigate it, identify whether or not there's merit, and respond as if it were within the 300 days. I think, just to clarify my message and how the social pressure is impacting the legal practice, I do think that the current climate is a very good thing. It's having this conversation and now gives me an opportunity. Employers are adequately aware and freaked out that there's going to be something that they don't know about that is going to be shared on Facebook or social media that is going to negatively impact them. Now they're having me come in and give presentations like this. Instead of just saying hostile work environment is repeated incidents that create an oppressive work environment, and I can get the exact legal definition, a pattern of abusive or degrading comments that creates an offensive and hostile work environment. And the law very clearly says that single or isolated incidents aren't sufficient to meet this standard. So you have a legal standard for sexual harassment, that is above what would make most people uncomfortable at work. And when we're seeing the complaints is when most people are initially uncomfortable at work. And now with people who are reporting feeling uncomfortable at work, but employers who aren't responding accordingly, not addressing it because they're operating on the legal standard, then they go to the court of public opinion or to generate awareness for this, and they get a response. The reaction of the employer has been to deal with it, again, at the initial complaint level. So when I say sexual harassment, I just read you the legal definition, but what we're talking about in practice and the types of examples that I see representing employers, and we're very rarely talking about the quid pro quo harassment, promotions or financial gains in exchange for some sort of sexual act, the Harvey Weinstein type thing. That is fortunately very, very rare. But the types of circumstances that can trigger the investigations and making people uncomfortable is the comedian, the person who pushes the boundaries with the appropriateness of their jokes, and they don't get, they say a joke that's questionable, everyone kind of chuckles as most people do to be polite and to not confront the issue, but then they continue and create an uncomfortable environment. Relationships in the workplace, always very tricky because consenting adults who are socializing at work, it is not uncommon for them to find significant others in the workplace. When everything is consensual and they're going out to lunch together or meeting before or after work and carpooling together and really intertwining their personal relationship with their work relationship, as long as everything remains consensual, there's no legal liability for the employer. What creates issues is when that relationship ends and then all of a sudden all of the cards and the advances and the flirty behavior on the clock, now none of that's consensual anymore. And I really didn't want any of that. I felt pressure to go out to lunch with him, or I felt pressure to, I didn't really, consent becomes a disputed issue of fact when the relationship is no longer going on. The vindictive person, I've had a couple of these. Willing participants in inappropriate conversations when it's just two employees. We're dealing with, the employer was a paramedic, they had long afternoons kind of just sitting on call in the ambulance and waiting for calls or traveling around from call to call. And him, it was a male and a female, had a very open conversations about many inappropriate things. After this employee gets some discipline, after the male employee gets some discipline that's related to his performance, all of a sudden everything that's happening in the ambulance makes him wildly uncomfortable, and he was just going along with it out of pressure and files a harassment complaint. The theme that you're probably seeing is, at the time that this is all going on, they seem to be a willing participant, but after the fact, when the complaint is filed, now whether or not it was voluntary or they consented to it becomes a disputed issue of fact. The result of that is, one, it's really hard to litigate intent. It's really hard for me to go in and say, no, you weren't uncomfortable, you were joking around and you were a willing participant. Unless we have some text messages or some emails where they are in fact saying the same type of inappropriate things. When you have a silent bystander who isn't doing anything one way or the other, either objecting or participating, it's really hard to litigate how that person feels. So the recommendation and kind of the gold standard for appropriate behavior is to don't invite it into the workplace. You don't create that environment. You don't have to weed through, all right, we have the dirty jokers over here, and then we have the people who are uncomfortable, and one of them is coming on our side, so let's not tell dirty jokes. That's a very difficult situation to navigate. And the recommendation to employers, even though it can be a Debbie Downer of a recommendation, is just to encourage a professional work environment. Still socialize, still have fun, but when you see things that are borderline, or when you have reason to believe, certainly, when you have reason to believe that people are uncomfortable with jokes, conduct, touching, that's when it should be reported and addressed, long before it's repeated or there's a pattern established, and then we start to get down the road of the legal standard. The misinterpretation and the never-ending pursuit, those are both situations where the person, the actor or the harasser, thinks that that they aren't doing anything inappropriate. The never-ending pursuit, they think that the person is genuinely interested or potentially interested, so they're getting the numbers, they're commenting on their anniversary, they're following them on Facebook, they're courting them, but at the same time making them feel wildly or very uncomfortable. Again, those are the types of behaviors that you encourage people not to engage in because, as I said, it's very difficult to litigate and prove that you were comfortable with this or you were a willing participant. Any questions about those general categories or types of behavior? Okay. The 5 categories I just went through are the result, in my estimation, of the change in the work culture. You have 50 years ago, you had manufacturer-driven work environment with a great deal, generally speaking, a great deal of segregation by the genders. You had females were predominantly office employees or in totally different occupations altogether. Males were in the male environment, the shop environment. There wasn't as much interaction of the genders. There certainly wasn't as much socializing in the collegial atmosphere of the workplace. I mean, most employers that I work with have kind of work-sponsored NCAA tournaments and work-sponsored socializing events and picnics, and everyone is friends with the people that they work with, and there's a blending of personal and professional relationships. And I think now the generations, and I think most people realize I'm going to spend a third of my life in this workplace. I would like to be there with my friends. I would like to have some levity and something a little more entertaining than working on the punch press 8 hours a day. But with that creates, again, the blending of the personal and professional environment, which then bleeds into the 5 categories that I talked about: the inappropriate jokes, the personal relationships, the misinterpretations. The funny example I like to share, or that I think is a funny example of 50-year workplace to today, is you have a vice president who has openly said he feels uncomfortable going out to eat alone with a female colleague. I mean, this is the era of I'm alone with a female worker. This feels inappropriate. This is so foreign to me that I have to have my wife here to observe. That's obviously absurd. And people in today's age would think nothing of socializing in happy hour with a mix of the genders. And again, that's the blending of the environment, the blending of the relationships that makes it really, really hard for an employer to police. Because what I'm saying is you can eliminate all your liability if you just discourage any of that personal blending at all. That's not a likely outcome, and it's not a very fun place to work. So what the employer has to do, and what all the employees have an input in, is creating the environment where they feel most appropriate, what they feel is comfortable. What the employer is absolutely responsible for is having an open channel, an open line of communication, and responding appropriately to harassment complaints. Because I think the other piece of this that has changed in the culture is people who have been subjected to hostile work environments or inappropriate conduct have said, I've reported it and nothing was done. That does go to the employer. And I know that this employer has, that Bev and Tammy take these complaints very seriously, and they work with me closely on these complaints to conduct an investigation and substantiate any complaints and then deal with them appropriately. So that is something that they have direct control over and that they take very seriously. So just some other examples, and again, these aren't intended to be mandatory steps that need to be taken, or if these steps aren't taken, there's an inherent risk for liability. They're just suggestions, and it's the culture of the individual employer that dictates which one of these they implement and put into practice. But it's encouraged that everyone be kind of proactive in policing this policy. Everyone here is now aware of these issues and can be eyes and ears on the ground on a daily basis. Someone that confides in you, that doesn't feel comfortable going to a supervisor, I certainly encourage you with having the knowledge that these complaints are dealt with seriously and promptly, encourage that person to go directly to management and report an issue or complaint. If you see something that is inappropriate, again, please, I encourage you to report it, because the point of this isn't to educate you on the law and everything that's appropriate up to the law. It's to educate you on how to police an environment and create an environment where everyone feels comfortable. Consider meeting locations and meeting rooms and kind of the content. When I say content, the composition of the people at a meeting. This presentation was drafted shortly after the Matt Lauer allegations, which was the closed-door, one-on-one meetings with the creepy lock under his desk or whatever he had. That last part doesn't apply, but the one-on-one meetings in offices without windows. I can tell you in our firm's offices, which have been redone in the last 5 years, it's most employers, but as I said, our firm as well, windows in all of the offices, just to avoid that issue. And when we're structuring meetings, planning meetings, just being cognizant of the supervisor-subordinate relationship and the timing of meetings and things like that. And again, it seems like a very benign issue, and how could that be interpreted as, but that misinterpretation category of potential harassment or hostile work environment is one that you have to be aware of as well. I schedule a meeting at 7:30 in the morning with my assistant, and her and I are the only two in the office, but that's when I'm going to be there, and that's when I need the work done. There's an outside element of it. There's an outside component to it that doesn't register with me, but again, could play a role. The off-hours socializing and kind of coworker dating and socializing and things like that. Each employer handles it differently. The general rule of thumb is you can't have, or we strongly discourage employers from having subordinates dating their superiors, but two coworkers who are just working in the vicinity of one another and don't have a direct reporting relationship. We still encourage open and honest discussion with the employer about the relationship, just because the employer then has knowledge of it. We're not policing our policy with these individuals because they are in a consensual relationship. If we see some flirting or some contact between those two, we now understand the context. We can also document in our notes that this relationship is consensual and has been disclosed to us. That helps on the back end when I have to litigate a dispute regarding consent, that this was in fact documented and reported and was an open relationship. Along the lines of the think before you act with the meeting time, location, composition, the same would go for personal cards, gifts, outside office communications. This is a public case, so I can talk about it, but we've been handling the issue with the Fox Crossing judge and the harassment of his judicial assistant. None of that rose to the level of overt sexual advances. The majority of that case was built on overstepping personal boundaries repeatedly, and despite constant and numerous directives to not send personal cards, send anniversary cards, acknowledge other milestones in her personal life through following her on Facebook, contacting her husband, her mother, other relatives. All of these things that in the judge's mind were benign and were an attempt to establish a relationship with her were really creeping her out and making her feel really uncomfortable. And the employment relationship was the most subordinate supervisor one that you can have. Statutorily, he has the authority to hire his clerk and fire her. And he's saying, unless you accept my friendship advances, again, there was nothing overtly sexual, but unless you're my friend, I'm going to fire you. And this, it kind of just snowballed to where it was recently with the violation of the injunction and now his judicial commission proceeding. But point from that story is this is personal cards. These are personal gestures that certainly can, when repeated and when asked to stop and you don't, can rise to the level of harassment. So the last piece I have is on the investigation process. I've said repeatedly about the reporting. I think that's pretty clear. But that piece is at your level, at the day-to-day employee or the mid-level supervisor. The reporting to management is the most important piece. You may be involved in the investigation as a supervisor or as a witness to an investigation. Just briefly on the investigation process, the employers can maintain confidentiality to a point. The National Labor Relations Act, another law that dictates or governs employment, and employers says that you can't tell employees not to discuss terms and conditions of employment. This is born out of union collective bargaining and the right for an employee to bring grievances to a union for organization purposes. It's been kind of interpreted to apply to any investigation, regardless of whether or not the employer is unionized or not. But what that means is you can't conduct an investigation and say, don't tell anyone about this. And you can disclose, or excuse me, you can keep confidential any facts that would embarrass or potentially harm or put anyone else in risk or jeopardy. And you can certainly encourage and ask that people keep everything confidential and remain discreet until you've had an opportunity to complete your investigation. But just so you know, if you're a witness and you're saying, well, I don't want to talk unless you can promise me no one else is going to know, or you can promise me that no one else is going to find out about this. So you know, if I get that call, you can't, the employer cannot make that promise. The employer cannot do that. But the investigation process involves evaluating and discussing the alleged incident or incidents with anyone who is potentially a witness, and then again, speaking to anyone who has secondhand information to either corroborate or dispute alleged facts. Obviously, the accused is someone else that is talked to get a determination of whether or not the complaint is substantiated. And then based on that investigation, Bev, Tammy, and myself will talk about the appropriate response and how to handle it. Documentation is always helpful in the litigation phase of these things. So if you have a report come to you, it's always helpful to have the person who's reporting have a brief written statement that they've signed off on that can memorialize the fact that they brought a concern to you, and then we have an initial report that's documented that can be used through the rest of the investigation process. It also helps us police a situation where facts are evolving, and we're trying to figure out what exactly the allegations are that we're investigating. Getting things in writing can help reduce any confusion or changes in statements after the fact. So if you're a witness and you have a statement, just know that that's my recommendation, to put your statement in writing. And if you're a supervisor managing these, getting the information that's reported to you in writing is also very helpful.
John,
Yeah.
just along those lines, sometimes we've had, the supervisor ended up coming to Bev and or I, but they would come with, the employee didn't want me to share this with you guys. Can you talk a little bit about that? Like, they just want to report it to their supervisor and not have it go any further?
Yeah, absolutely. That is not uncommon. And so I mean, that information, no matter what form it comes in, an anonymous email, anonymous letter, someone, a third party saying, I heard this, but they don't want to be known, or they don't want to make a big deal out of this. The employer doesn't have that luxury. The employer, the legal liability is tied to the employer regardless of whether or not the person who reported it wants to act or wants any action. I talked about that knowledge and appropriate response. Well, now you have the knowledge. and the law requires an appropriate response. So the employer has to conduct an investigation, has to speak with the accuser and the accused, and evaluate and investigate the complaint. And I know that that causes concern for employees who may work in a small environment and don't want someone to get in trouble, or don't want to be viewed a certain way as complaining about behavior that the masses find appropriate. I mean, I've had cases like that where a large group of individuals are willing participants and they really don't want it, they don't like it, and they've complained, but they don't want to be attached to the complaint. There are circumstances where the employer, depending on the severity of the complaint, can do their best to police their policies without outing an individual employee. But when there's a complaint of one employee was inappropriate to another employee, the employer has to go and talk to both of those employees and discuss, evaluate the nature of the conduct. Yeah. Any other questions? I don't have much else prepared. We did this presentation with Monica Erdman, who's an equal rights officer from the Wisconsin Equal Rights Division. She conducts the initial investigations at the ERD level. We talked about the drafting of position statements. Most of that is outside the scope of this presentation, but she did say that important components to the employer's response, again, is the knowledge and the promptness and thoroughness of the investigation, and then how the employer responded. The ERD, and regarding that response piece, the ERD provides a lot of discretion to the employer to craft an appropriate remedy. The law doesn't dictate, if you find someone harassed someone, that person has to be fired. The law doesn't get to that point. The law simply says employees should not be subjected to offensive or hostile working environment. So when you identify a situation where someone has done that, or has done conduct that almost amounts to that, there isn't a directive or a requirement under the law that that person be fired. Now, you certainly have to eliminate any contact between those people and make sure that the conduct doesn't persist. But what the employee thinks is the appropriate response, or what the employee says would make them comfortable, isn't necessarily what the employer is obligated to do under the law. So, and the ERD investigator spoke to that as well. That the employee would file a complaint because they investigated it, they said yes, he or she did something inappropriate, but he still works there. The investigator was very clear that isn't a basis for a claim, that isn't harassment because the accused wasn't fired. Plenty of circumstances where termination is recommended and has to be the outcome because there's no other workaround, but again, it is not the only outcome.
So
Yes.
it would be better basically if, like, employees were dating, if they both came and told their employer, instead of like one coming in and saying, well, we're dating.
Yeah,
Just to avoid issues.
yeah, and this is employer specific, and I don't know, and Bev and Tammy and I haven't talked about this issue, so, but it is generally my recommendation to any employer that I represent that you ask employees to disclose that, and how the disclosure looks and what the formality of it is kind of up to the employer. But I do, as the employment attorney who has to deal with the slide said good, long, and gone bad, who has to deal with those types of things, like I said, consent becomes, and when you have two people who are in a relationship at work, there's not inappropriate, but there's personal emails, there's personal texts during work time, there's little gifts, there's a ton of stuff that if this was just two coworkers and you have one person saying, I didn't want any of this, there's a ton of things that cross the line. But when you have some sort of documentation just memorializing, these two people came to me, they said that they really like each other and they're gonna start dating, they understand work time is for work and they're not gonna let that interfere, well now I can say, here's the timeline. They weren't, now here they're dating, now here they broke up. Everything that happened from the time we got this letter to the time they broke up is what she's saying was, or he was saying, is the inappropriate boundary crossing. It just kind of fulfills, it builds a timeline for me to work with. Kind of gives me that benchmark, the employer, the benchmark that this is when a consensual relationship began. And not to get too into the weeds, I mean, I'm not saying that two people who go out and have a happy hour together have to tell the employer. It doesn't have to get to that absurd level, but again, it's something that when I'm in the litigation phase and there's a dispute about a relationship that I ideally would have effects toward. Any other questions? Anything else that you wanted me to cover?
No, just probably the other thing, and I'm not sure if it's covered, if it falls under this realm, is like in some of our residential homes, it's so far has been, thank goodness, at the supervisory level, but it's sort of like, well, I'm not blaming anyone in the rooms, but it's like, oh, the night person didn't get all the dishes done because they want me to do it when I'm there during the day and because they're mad at me or whatever, and it sort of becomes borderline a little hostile, retaliation-ish, and I think they're all talked to, but is that under this too? Like if you're just feeling like someone's targeting me or?
Usually and I thank you for that because I didn't include it, usually the hostile work environment, the sexual harassment has like an inappropriate sexual component to it. However, feeling singled out and kind of treated differently on the basis of gender would be a discrimination complaint. Now, in order to prove that, you would have to prove that this employee is not doing the dishes and sticking me with the work because I'm female or I fit into some other protected class. So it's not just that this person has less work than I do, it's that this person, I'm being treated differently because of my membership in this protected class. So there's a couple other elements to establish before the situation that you just described would rise to the level of.
Could it just be viewed as hostile, like they just don't like me, so they're leaving all this work here?
If it's not tied to a sexual component or on the basis of their gender,
Okay.
just like, this is a bad place to work, or I'm getting too much work, like that, there's no lawsuit for that.
Okay.
I think, yeah. So that, again, if there's a reason to think that they're doing this because they don't like me because of my membership in a protected class. I mean, we have seen cases like that,
Okay.
that I don't like this coworker, so I'm gonna stick them
Your
with these
destination
crap
is on the
jobs.
left.
Made it.
Delayed.
But yeah, just that report and that issue would kind of fall under just general HR,
Okay.
personality management and work assignments.
I have a question, it's like, this was with a different company, but someone made a comment to a new employee about, oh, you're the low man on the totem pole, so you're gonna have to cover Christmas and stuff. And they brought a claim because it turns out she has Native American blood in her. Unfortunately, she was full-blooded Irish. How, I don't assume that the employee was trying to be racist. It's a common
Yeah,
cliche phrase.
yeah, there's a Seinfeld episode about Indian timber that was along those lines. It is a saying that is used and to the wrong person, it carries a whole different meaning. What you have to prove in any discrimination complaint is motive, so that they said this, you would have to, in that specific case, you'd have to prove that they had knowledge of it. You can't discriminate against someone on the basis of a disability if you have no idea that they were disabled. You can't discriminate on someone on the basis of national origin if you don't know what their national origin is. So if that, in that fact scenario, the problem the employee would have would be proving that that was the motivation. Now, again, it goes to legal standard versus inappropriate and making people feel uncomfortable. And there are plenty of comments that don't rise to that level that make people feel uncomfortable and inappropriate. And things that are appropriate to say in the workplace, I mean, that's a moving target, and that's kind of evolving all the time. What some person would just laugh off, deeply offends, and I'm not even talking about jokes, I'm just talking about like what's in the news. I mean people are prone, I'm not gonna people
people can get upset about a lot of different things, and the legal standard of how it ties back to a protected class or how it ties back to sexual harassment is very different than I'm coming into a workplace and all they're talking about is fill in the blank, current event, and they feel very strongly the other way, and they're being inundated with this viewpoint, and they feel like it's a hostile work environment. That's an that's a management issue, and that's something to address, but that's outside of and not really crossing any boundaries with the legal side.
Okay.
Yeah. Any other questions? All right. Thank you guys very much for your time.
Thank you.
If everyone wants to just move around just a little bit, but don't leave, FMLA's up next.